Well, thank you all for coming. I am very pleased to introduce Judge Bill Pryor of the 11th Circuit Court of Appeals. He's been on the 11th Circuit since 2004. Prior to that, he was Attorney General of the state of Alabama. Judge Pryor got his JD from Tulane University. He served as a law clerk to Judge John Minor Wisdom on the 5th Circuit, confirming if you want to go anywhere in life, you need to clerk for a judge. Frequent theme of mine. More importantly, and closer to my heart, he actually teaches federal courts at the University of Alabama School of Law. He was the youngest attorney general in the nation when he became attorney general in Alabama. And in 2003, he had a famous interaction with Alabama Chief Justice Roy Moore about the Ten Commandments in the courthouse. He's going to be speaking to us about moral duty and the rule of law. So please welcome Judge Pryor.
Thank you. I have a mic on. Can everyone hear me well? I want to thank you for the warm welcome that I've had at Duke Law School, arranged, I think, primarily by one of my future law clerks. And I have had a terrific experience today, and I feel it's a real privilege to be at a law school with such a great national reputation. One of my colleagues is a famous alum of this law school and a real institution on our court, and your school enjoys a great reputation on our court, and it's been a great opportunity too today to spend some time with Professor Young, who also has a great reputation among those of us who appreciate scholars of what we do in the federal judiciary. I guess my address today confirms the lesson that economists have taught us for centuries, and that is that there's no such thing as a free lunch. So the cost of your lunch is the experience of listening to me. I hope that I'll make you feel like at the end of the day, the cost-benefit analysis was weighed correctly, and it made it a worthwhile experience for all of you. I feel like, though, that I'm a big draw whenever I come to a law school, and the posters around the school advertise the address with the line, "A non-pizza dinner will be served." This is a big deal event. So I want to thank you too for allowing me to share in a non-pizza dinner this afternoon. In his immortal play, A Man for All Seasons, Robert Bolt provides a fictional account of an argument between Sir Thomas More, who served as Chancellor of England and would later become the patron saint of lawyers and politicians, and his son-in-law, William Roper. Their argument is about the demands of fidelity to both law and morality. In the course of that argument, More pleads, "The law, Roper, the law. I know what's legal, not what's right, and I'll stick to what's legal." Roper then makes two provocative charges against More. First, Roper asserts to More, "Then you set man's law above God's." More responds in the negative, "No, far below. But let me draw your attention to a fact. I'm not God. The currents and eddies of right and wrong which you find such plain sailing, I can't navigate. I'm no voyager. But in the thickets of the law, oh, there I'm a forester. I doubt if there's a man alive who could follow me there, thank God." Later, Roper charges, "So now you'd give the devil benefit of law." To that charge, More responds in the affirmative and asks a question of Roper. "Yes, what would you do? Cut a great road through the law to get after the devil?" Roper then falls into the trap when he answers, "I'd cut down every law in England to do that." More then offers the most memorable lines of the entire play. "Oh, and when the last law was down and the devil turned round on you, where would you hide, Roper? The laws all being flat. this country's planted thick with laws from coast to coast, man's laws, not God's. And if you cut them down and you're just the man to do it, do you really think you could stand upright in the winds that would blow then? Yes, I'd give the devil benefit of law for my own safety's sake. Robert Bolt's portrait of St. Thomas More offers lawyers and judges the right role model. I've been asked today to reflect on my personal experiences, both formerly as a state attorney general and as a nominee for a federal judgeship, who was embroiled in controversies about the potential conflict of moral and legal duties. The stakes of those controversies, thankfully, were not nearly as high as those that led to the execution of St. Thomas More, but they were at least high drama in the contemporary arena of American law and politics. In each instance, the law offered me the right path to follow. My first experience came in June 2003, 2 months after President Bush nominated me to serve as the United States Circuit Judge. That nomination was controversial for several reasons, among them my public criticism as a politician of the decision of the Supreme Court in Roe v. Wade, my defense as Attorney General of Alabama of a law that made sodomy a crime, and even my decision as a parent to plan a family vacation at Disney World so as not to coincide with the Gay Day festivities at the park. During my confirmation hearing, a few members of the Senate Judiciary Committee raised questions about what they termed my, quote, deeply held beliefs, and whether I was, in their words, asserting an agenda of my own, a religious belief of my own, inconsistent with separation of church and state. When the committee chairman, Senator Hatch, responded to these statements by asking about my Catholic faith and then asserting that, quote, in every case he could see, I had, in his words, followed the law regardless of my religious beliefs, two other senators objected to Chairman Hatch's reference to my religion. Later that summer, an interest group sponsored political advertisements that described opponents of my confirmation to the bench as engaged in discrimination against me based on my Catholic faith. The advertisement portrayed a sign that read, "Catholics need not apply," hanging on a door to a federal courthouse. That advertisement created a furor in the Senate and a lively debate in national newspapers and magazines. My second experience came at the end of that same summer, when Roy Moore, who was then the Chief Justice of Alabama, refused to obey an injunction of a federal district court that required the removal of a monument of the Ten Commandments from the rotunda of the Alabama Judicial Building. As Attorney General, I publicly disagreed with Moore and assisted the Associate Justices of the Supreme Court of Alabama in ensuring compliance with the injunction. After the Alabama Judicial Inquiry Commission then filed charges of misconduct against Moore, I personally prosecuted the charges in the Alabama Court of the Judiciary, which unanimously granted my request to remove Roy Moore from his judicial office. Throughout these experiences about the potential conflict of legal and moral duties, my perspective has been that I should follow the example of St. Thomas More. My Catholic faith is the foundation of my worldview, and my judicial duty is governed from beginning to end by the law. Faith properly informs the religious lawyer or judge, and morality is not in tension with fidelity to the law. I will first address my perspective about the controversy that affected my judicial nomination, the role of religion in judging. Religious faith properly informs me as a judge in my fidelity to my judicial duty in at least four ways: in my understanding of my oath of office, in my moral duty to obey lawful authority, and in my responsibility to work both diligently and honestly. Each of these ways is motivational. That is, each concerns the judge's duty to perform his work well. None involves using religious doctrine to decide a case in conflict with law. The most fundamental way that faith properly matters to me as a judge is in my understanding of my judicial oath of office. The framers required in Article 6 of the Constitution that officers of our government, including judges, be bound by oath or affirmation to support the Constitution. And the next part of that clause, they provided that no religious test shall ever be required as a qualification to any office or public trust under the United States. The framers thought that the particular religious beliefs of a judge should not matter, but that it was crucial for the judge to have his conscience as informed by those beliefs bound by the Constitution. Many of the states had a different rule. Delaware, for example, in Article 22 of its Constitution of 1776, required officers to profess faith in God the Father and in Jesus Christ, his only Son, and in the Holy Ghost, one God, blessed forevermore, and to acknowledge the Holy Scriptures of the Old and New Testament to be given by divine inspiration. Vermont, in Chapter 2, Section 9 of its Constitution of 1777, required legislators to declare, "I do believe in one God, the Creator and Governor of the universe, the rewarder of the good and punisher of the wicked, and I do acknowledge the Scriptures of the Old and New Testament to be given by divine inspiration, and own and profess the Protestant religion." I'm especially grateful that last line of the Vermont Constitution did not become part of the federal Constitution. A lot's changed in Vermont. During the ratification process, some Americans objected to the ban of religious tests, as many Protestants feared the election or appointment of Catholics to federal office. James Iredell, a delegate, fittingly today here at Duke, to the North Carolina ratifying convention, provided my favorite rejoinder to these objections when he rose to defend the ban on religious tests on July 30th, 1787. His words were especially memorable for Catholics. Iredell said, "I met by accident with a pamphlet this morning in which the author states as a very serious danger that the Pope of Rome might be elected president. I confess this never struck me before, and if the author had read all the qualifications of a president, perhaps his fears might have been quieted. No man but a native, and who has resided 14 years in America, can be chosen president. And I know not all the qualifications for a pope, but I believe he must be taken from the College of Cardinals, and probably there are many previous steps necessary before he arrives at this dignity. A Native American must have very singular good fortune who, after residing 14 years in his own country, should go afterward to Europe, enter the Romish orders, obtain the promotion of cardinal, afterwards that of pope, and at length be so much in the confidence of his own country as to be elected president. It would be still more extraordinary if he should give up his popedom for our presidency." Sir, it is impossible to treat such idle fears with any degree of gravity. The framers' general understanding was that prescribing religious tests did not necessarily remove the religious significance of the general oath. James Madison, the father of the Constitution, for example, explained in a letter to Edmund Pendleton, dated October 28, 1787, that an oath should make a religious test unnecessary. Madison wrote, "It is not a religious test as far as it is necessary or would operate involved in the oath itself. If the person swearing believes in the supreme being who is invoked and in the penal consequences of offending him, either in this or a future world or both, he will be under the same restraint from perjury as if he had previously described a test requiring this belief. If the person in question be an unbeliever in these points and would notwithstanding take the oath, a previous test could have no effect. He would subscribe to it as he would take the oath without any principle that could be affected by either." Madison's argument, expressed by others, was that a religious believer would take an oath seriously without need of a religious test, and that a religious test could be declared by an unprincipled atheist without fear of punishment or death. Either way, a religious test was unnecessary. When I placed my left hand on the Holy Bible and swore to perform all the duties incumbent upon me as a United States Circuit Judge under the Constitution and laws of the United States, and swore that I would well and faithfully discharge the duties of the office on which I'm about to enter, so help me God, my conscience was and remains affected by my religious beliefs. Were it not so, what would be the point of placing my hand on the Bible or ending the oath with the declaration, so help me God? Taking a false oath is a violation of the second commandment, not to take the name of the Lord in vain. As the Catechism of the Catholic Church explains, taking an oath or swearing is to take God as a witness to what one affirms. It is to invoke the divine truthfulness as a pledge of one's own truthfulness. An oath engages the Lord's name. My entire understanding of my judicial duty flows from taking my oath seriously. James Madison and the other framers of the Constitution expected nothing less. My religious faith also informs my perspective on my judicial duty to obey lawful authority. I believe I have a moral obligation to obey our government and its laws. Before I became a judge, this perspective informed my decision as the Attorney General of the state, which I will address in a moment, to obey the federal injunction that required the removal of the monument of the Ten Commandments in the Alabama State Judicial Building. My moral duty to obey the law pertains to my judicial duty now as it pertained to my executive duty then. My faith informs my judicial duty in a third way, by inculcating me with a belief in the moral duty to work. I believe that work is, in a real sense, a form of prayer. This religious belief motivates my commitment to my oath to well and faithfully discharge the duties of the office of a circuit judge. The final way my faith informs my performance as a judge is by teaching me to be honest. The moral duty of honesty requires both truthfulness in communication and reasoning and respect for the property of others. This duty is reflected in the commandments against bearing false witness and stealing, respectively. Regarding the former, the Catechism has the following strong words about the necessity for truth in a judicial system. When it is made publicly, a statement contrary to the truth takes on particular gravity. In court, it becomes false witness. When it is under oath, it is perjury. Acts such as these contribute to condemnation of the innocent, exoneration of the guilty, or the increased punishment of the accused. They gravely compromise the exercise of justice and the fairness of judicial decisions. Although my religion properly informs and motivates me to be faithful to my oath and to my moral duties to obey the government and its laws and to work both diligently and honestly, there is a limit to the relevance of religion in the performance of my judicial duty. That limit is defined by the very nature of my judicial authority. Properly understood, the exercise of my authority as a judge is governed by the law alone, and that understanding is where the real controversy exists in the contemporary debate about judicial authority. As a judge, I'm not given the authority to use a personal moral perspective to update or alter the text of our Constitution and laws. The business of using moral judgment to change the law is reserved to the political branches, which is why the officers of those branches are regularly elected by the people. A judge's task is limited to serving, in Chief Justice Roberts' words, as an umpire, so that controversies between citizens and officers of their government may be resolved based on the law. For that limited task, a federal judge is granted a privilege designed to secure his independence, life tenure with no reduction in salary. An officer of a political branch, such as Congress, is free to propose changes in the law that conform with his perspective of morality as informed by his religion. For centuries, members of Congress have supported a variety of new laws on this kind of basis, whether to abolish slavery, withdraw troops from foreign wars, abolish child labor, guarantee civil rights, provide assistance to the poor and sick, protect marriage, or prohibit the sale of intoxicating liquors. The changing of laws enacted by political authorities is not a judge's task. The duty of a judge is the application of those laws in controversies within the jurisdiction of the courts. I do not mean to suggest that the task of judging is either mechanical or easy. The meaning and application of the law is sometimes difficult to discern, which is why judges in good faith sometimes disagree. The duty to administer justice requires the exercise of judgment, but not the employment of religious doctrine as a source of authority to supplant or evade the law when judging becomes difficult or its outcome undesirable. A judge who is motivated by moral duties to fulfill his oath and obey the law must strive to be as objective as possible using traditional methods of construction, reliance on precedent, and legal reasoning. This limited understanding of the judicial role has served our nation well for more than 2 centuries. It has allowed our judiciary as a separate branch to perform when necessary its vital role of demanding compliance with the Constitution. In short, the rule of law that flows from the separation of powers has preserved our freedom. With that understanding of my moral and legal duties in mind, allow me to return to my experience as Attorney General of Alabama to illustrate how my understanding guided me. In the days following the removal of his monument of the Ten Commandments, Chief Justice Roy Moore and his prominent supporters advanced three arguments against those of us who complied with the federal injunction. They argued, first, that we had a moral duty to acknowledge God that required us to disobey the injunction. Second, as they surrounded the state judicial building in hopes of preventing the removal of the monument, Moore's prominent supporters compared their struggle with that of the civil rights movement led by Dr. Martin Luther King Jr. In turn, they compared those of us who complied with the federal injunction with the defenders of racial segregation. Finally, Moore argued that we had a duty to disobey the injunction as we would, he argued, if the injunction had allowed slavery. I disagreed with Moore. I argued that I had a moral duty as a Christian to obey the federal injunction. There was no moral justification for civil disobedience. My oath to uphold the U.S. Constitution required me as Attorney General to obey the injunction without regard to whether I agreed with the basis of that injunction. My moral duty was not in conflict or even tension with my legal duty. My Christian duty instead provided the foundation for my public duty. I explained that the Christian duty to obey the government and its laws is clearly expressed in the New Testament. In St. Matthew's Gospel, Jesus gave a provocative lesson about the moral duty to obey the government. Repay to Caesar what belongs to Caesar, and to God what belongs to God. In his epistle to the Romans, the Apostle Paul taught, "Let every person be subordinate to the higher authorities, for there is no authority except from God, and those that exist have been established by God." And in his first epistle, Peter wrote, "Be subject to every human institution for the Lord's sake, whether it be to the king as supreme, or governors as sent by him, for the punishment of evildoers and the approval of those who do good." During the several years that I served as Attorney General, I defended the constitutionality of depicting the Ten Commandments in a courthouse. I assisted the governor in creating a display of several foundations of our law, including the Ten Commandments, in the old Supreme Court library of the state capitol. I publicly agreed with the opinion written by the late Chief Justice Rehnquist that the Ten Commandments, quote, have made a substantial contribution to our secular legal codes. Nevertheless, in the controversy about Roy Moore, I was obliged, legally and morally, to obey the injunction of the federal court. Removing the monument of the Ten Commandments from the building of the government did not require me or another official to violate a moral duty. Christ did not command anyone to maintain a monument of the Ten Commandments in the rotunda of a courthouse. The legality of a monument in the rotunda of Caesar's courthouse is a question for Caesar. What about the second accusation? Did compliance with the injunction violate the civil rights of Christians? Were the protesters outside the state judicial building engaged in rightful civil disobedience? Was Chief Justice Moore the new Dr. King and I the modern-day Bull Connor? The answer to all these questions is no. The authoritative text on this issue I submit is the letter written by Dr. Martin Luther King Jr. from the Birmingham City Jail on Easter weekend 1963. The letter was addressed to liberal white clergy of Birmingham who opposed segregation but did not support Dr. King's nonviolent protest against segregation. The white religious leaders argued that as a Christian, Dr. King had a duty to obey the government. King responded that he was not obliged to obey an immoral or unjust law. King argued, based on the writings of St. Augustine and St. Thomas Aquinas, that an unjust law is a human law that is not rooted in eternal and natural law. King contended that segregation statutes are unjust because segregation distorts the soul and damages the personality. He explained, a law is unjust if it is inflicted on a minority that as a result of being denied the right to vote had no part in enacting or devising the law. He concluded the law is unjust when it is used to deny citizens the First Amendment privilege of peaceful assembly and protest. King's case was that segregation treated black persons as less than citizens and gave them no political recourse to remedy their injury. Then King explained the difference between unjust defiance and just civil disobedience. He wrote, "In no sense do I advocate evading or defying the law as would the rabid segregationists. That would lead to anarchy. One who breaks an unjust law must do so openly, lovingly, and with a willingness to accept the penalty. I submit that an individual who breaks a law that conscience tells him is unjust and who willingly accepts the penalty of imprisonment in order to arouse the conscience of the community over its injustice is in reality expressing the highest respect for law." Dr. King's letter belies any comparison of the civil rights protests of 1963 in Birmingham and the protest of Roy Moore and his supporters in 2003 in Montgomery. The injunction to remove the monument did not distort the soul or personality of Christians because Christianity is not dependent upon the presence of a monument in a government building. The injunction did not represent a government denial of political recourse for Christians. Christians still enjoy the constitutional rights to vote, hold office, speak, exercise our faith, and assemble. Indeed, the election of Roy Moore and the peaceful protests for 2 weeks outside the state judicial building, complete with extensive freedom of the press, illustrated the vitality of the civil rights of Christians. The most fundamental distinction between Dr. King's example and Roy Moore's example is the difference between defiance of the law and civil disobedience. Dr. King expected the law he called unjust to be enforced against him. But Roy Moore and his supporters said that they expected our state officials not to enforce the injunction. Dr. King was a private citizen who, in his words, lovingly accepted the punishment of an unjust law. But Roy Moore was a public official who refused to obey and sought to evade any punishment or responsibility. A private citizen may, in extreme circumstances, engage in civil disobedience by accepting the punishment of an unjust law, but a public official has no such option. A public official is sworn to uphold the law. Perhaps the greatest irony was the reaction of Roy Moore's supporters following the removal of the monument from the rotunda. When he complied with the injunction, the supporters of Moore called on me to resign. As a public official, if I am ever unable to fulfill my oath and obey the law, then I should resign. The duty of a public official brings me to my response to Roy Moore's final contention, that we were obliged to disobey the injunction as he argued we would disobey an order allowing slavery. After the associate justices unanimously ordered the building manager to comply with the injunction, Roy Moore said, quote, "If the rule of law means to do everything a judge tells you to do, we would still have slavery in this country." This assertion is contrary to the American history of the abolition of slavery, especially the example set by the great emancipator, Abraham Lincoln. An infamous decision of the Supreme Court, of course, promoted slavery. In 1857, the Supreme Court ruled in Dred Scott that the Missouri Compromise, which prohibited slavery in western states and western territories, was unconstitutional and that blacks were not citizens. Abraham Lincoln argued that Dred Scott was wrongly decided and must be opposed. But Lincoln's perspective about the proper response to Dred Scott is instructive. In October 1858, Lincoln explained in one of his famous debates with Stephen Douglas as follows: "We oppose the Dred Scott decision in a certain way. We do not propose that when Dred Scott has been decided to be a slave by the court, we as a mob will decide him to be free. We do not propose that when any other 1 or 1,000 shall be decided by that court to be slaves, we will in any violent way disturb the rights of property thus settled. But we nevertheless do oppose that decision as a political rule which shall be binding on the voter to vote for nobody who thinks it wrong, which shall be binding on the members of Congress or the President to favor no measure that does not actually concur with the principles of that decision. We propose so resisting it as to have it reversed if we can, and a new judicial rule established on this subject. Lincoln explained that there were two ways of opposing a decision of a court allowing slavery. One method of opposition was illegitimate and to be avoided. The other method of opposition was legitimate and necessary. The illegitimate opposition was defiance of a final order of a court. Lincoln recognized that the Constitution in Article 3 created a judiciary to resolve disputes, particularly involving the interpretation of the Constitution. Upon the resolution of their dispute, the parties to the lawsuit, in Lincoln's view, were obliged to follow the orders of the court, and non-parties were obliged to respect the resolution of that dispute between the parties. Public officials sworn to uphold this constitutional framework for resolving disputes were obliged to enforce the final orders of this process as between the parties, without regard to the public official's opinion on the correctness of the ruling. The legitimate method of opposition, according to Lincoln, was political. Voters should support candidates who would work to end slavery. Elected representatives should enact laws to end slavery, and the judiciary should, in proper cases, reverse its erroneous decisions that promoted slavery. Lincoln also supported another, more provocative method of opposition. Lincoln refused to allow the Dred Scott decision to bind his administration. Lincoln required his administration, for example, to issue a passport to a black student and a patent to a black inventor. Lincoln supported policies of the government that challenged the continuing application of Dred Scott because Lincoln considered those policies constitutional, notwithstanding the erroneous precedent in Dred Scott. As Lincoln explained in his inaugural address, the candid citizen must confess that if the policy of the government upon vital questions affecting the whole people is to be irrevocably fixed by decisions of the Supreme Court the instant they are made in ordinary litigation between parties in personal actions, the people will have ceased to be their own rulers, having to that extent practically resigned their government into the hands of that eminent tribunal. When the judiciary interprets the Constitution erroneously, the American people still retain all the lawful tools of political opposition that Lincoln employed. The American people can campaign for different policies. They can elect candidates who will enact their favored policies. Elected officials can appoint judges faithful to the rule of law. The American people can bring new cases before the courts and urge the overruling of erroneous precedents. If necessary, the people can even amend the Constitution. But defiance of the law is not a remedy under the Constitution. Contrary to Roy Moore's arguments, slavery did not end through the defiance of an injunction by a public official. Slavery was abolished following our bloody Civil War with the adoption of the 13th Amendment to the Constitution. The rebellion of the southern states set the wrong example of defiance. Many might say, and I would agree, that it is easy to see why Roy Moore was wrong to take the law into his own hands. Because our liberty depends on the rule of law, we are all bound to obey even when we disagree with the decisions of our courts. As St. Thomas More said, "The law, Roper, the law, I know what's legal, not what's right. I'll stick to what's legal." But the controversy about Roy Moore raises another question. What about those who applaud or publish glowing editorials when other judges place their own different notions of morality above the law? That wrong can be done from either the right, as in the case of Roy Moore, or the left. The law is not a mirror that will always reflect our individual notions of right and wrong. For courts, questions about morality, including the death penalty, marriage, and family, for example, are to be resolved based on the law, not based on what a majority of lawyers or judges think the law should be. Legislators and voters may change the law and be informed by morality in that endeavor, but none of us has the authority to defy or subvert the law in the name of morality. Faced with a conflict of law and morality, we should follow the example of St. Thomas More, who resigned as Lord Chancellor after King Henry VIII left his wife, Catherine, for relations with Anne Boleyn, and the clergy surrendered the property of the Church of England to the king. When the English Parliament passed the Act of Succession, which made Anne Boleyn's issue first in succession to the crown, St. Thomas More said he would swear to the succession, for it was the law of the land. But he refused to declare the supremacy of the king over the church. St. Thomas More recognized clearly his duty to render to God what belongs to him, while rendering to Caesar what belongs to him. In his devotion to duty, St. Thomas More paid the ultimate price. As More succinctly explained a moment before his execution, he died the king's good servant and God's first. St. Thomas More lovingly accepted the punishment of an unjust law like Dr. King did centuries later in America. But both St. Thomas More and Dr. King rejected the path of defiance, evasion, and subversion of the law. They recognized that path would lead, in Dr. King's words, to anarchy, when moral duty instead required the highest respect for the law. Those who would, like William Roper or Roy Moore, cut down the law to get after the devil risk falling into his trap. When the devil turns around, where will they hide, the laws all being flat? For me, I will strive to follow St. Thomas More's example and give even the devil the benefit of law for my own safety's sake. Thank you.
So I'm curious about your example of the Lincoln administration pushing back against the Dred Scott decision,
Right.
and to try it maybe in a different context and see if you would come to the same conclusion, that if, for example, the Supreme Court declares homosexuality a protected class and applies Loving versus Virginia in that circumstance, and then a president and Congress continues to push the Defense of Marriage Act.
Right.
Are they justified in doing so, in standing up to the Supreme Court, or is that illegitimate?
I think that recourse to political opposition to court decisions is, as Lincoln saw it, legitimate, a part of the process. A lot of what guides the decision makers, the political actors in that kind of circumstance, is a political judgment more so than a legal judgment. There's a risk for them. Public institutions do not perhaps enjoy some of the respect that they have enjoyed at other periods in American history, but the branch that, although it suffered at times, even in recent years, the branch that still is the more respected of the three is the judicial branch. And I think when the court issues a decision that very often the public wants to support the decision. Of course, I would argue too that there have been recent instances where the courts waded into something where the law did not support what it was doing, and it has given up a lot of its moral authority and persuasiveness to its greater detriment in other areas as well. But there's a cost for the other branches too when they oppose court decisions, and because again, I think the American people still, at the end of the day, want to believe in the independence of their judiciary, want to believe in the rightness of our system, and they want the decisions of the court to be respected. That's not to say that the American people will always respect the decisions, and the Dred Scott example is a great one of using that, where through the test of history, we know that the decision was wrong on every level, and where we can see that it's okay for those who feel strongly that way to oppose and to allow the political process to play out. But there are costs to that. Lincoln certainly experienced the cost. The first office to which he was ever elected was president. He lost elections before that, but he plugged away nonetheless. But yeah, I would say that is an option available. But I would agree too with Lincoln that at least as between the parties to a case decided, that we have to respect and not violently oppose or resort to defiance of the legal process. Yes?
You had talked about your duty as a public official to follow the law if that is the law, regardless of your beliefs. But then looking at Martin Luther King and looking at even Thomas More, both of them in at least one instance decided they were going to violate that and then lovingly accept the consequences.
Well, but Dr. King wasn't a public official, and Dr. King didn't take an oath. And St. Thomas More was a public official, but what was his response when faced not just with a singular example of something where perhaps he could recuse himself or step aside for this one problem? He saw the problem as being so pervasive in the duties that confronted him that he resigned his public office. What I'm speaking from is the perspective of a public official. So long as you're going to take on that responsibility, defiance or evasion is just not an option. Perhaps your option will be the option exercised by St. Thomas More to resign altogether. He thought that he could happily do that and avoid the problem. The king had different ideas. He wasn't satisfied with that. But Dr. King was never a public official. So when he was taking on the regime and defying the law, accepting punishment, he wasn't doing so with the obligation that comes with any oath of a public official.
Just to follow up briefly, so would it sometimes be a public official's duty then, if they felt strongly enough to resign from that position?
Yes. I always thought, it's the first time I've ever said this publicly, I always thought that Roy Moore might have gone out as a hero if that's what he had done. If he had said, I just can't comply with this injunction, no matter how much I might have agreed that depictions of the Ten Commandments can be okay on public grounds. And we now know, thanks to those very clear and bright line rules that the Supreme Court has given us, that in at least some instances it can be okay, right? But no matter how much I felt that way, I can't imagine feeling so deeply about it that I would think, you know what my view is. It's Caesar's courthouse. If Caesar says that we're not going to have this kind of monument, I don't view that as any kind of moral quandary. But if he really felt that strongly about it, as many Alabamians, I think, shared his sentiment, then that was obviously an option available to me. One that I think would have been respected widely and popular widely. He was popular at the beginning, and I wasn't. but over time, the mood changed, and over time, the reflection of the public, I think, and understanding of the public, appreciation of the public, changed as well. I don't think the public and the voters ever get nearly as much credit from elites and media and others as they deserve. I think at given time, they sort out a lot of these issues pretty well, and that was an example of it. Although it'll be tested soon. The news media reports that Roy Moore intends to run for governor of Alabama again next year. So, the fun is coming. Yes, sir.
Following up a little bit on the last question, let me propose a hypothetical and ask you. Imagine President of the United States receives a decision from the Supreme Court that is contrary to his view of what the clear meaning and understanding of the Constitution tells him is right. He openly defies the Supreme Court.
Right.
This is Andy Jackson Jr., perhaps.
Yeah, right.
And says, and there it is. And
there it is.
Leaves it in the lap of Congress to decide whether or not they should exercise powers of impeachment as the balance to that.
Yeah.
I suspect that from what you've said, you would hold that the president, as a public official, has somehow violated his duty.
I do think he has violated his duty.
But if he does, if that's true, then
Yes.
are we not making the Supreme Court supreme over the other two branches, and don't we run the risk
No,
of trashing the Constitution?
no. Look, at the end of the day, the political remedy is going to be the one that you suggested, and that is impeachment. And it may be that it is what I think is a wrong that goes unremedied, and that's part of our system too. But at least as between the parties to whatever that litigation were, I think the president has a constitutional obligation to respect the rule established as between the parties. That does not mean, though, that...
Why is his view of the Constitution inferior to that?
I don't think that it's inferior, but as between, when the Constitution itself, when Article 3 has entrusted cases or controversies to the jurisdiction of the courts, then after that process has played out according to the rules, and the court has reached its decision, I don't think that the Constitution creates any review of that judgment. At the end of the day, that's the final word in that case or controversy. I don't think that that's giving up a lot. It's just that case or controversy. It's not a rule that it will necessarily has to bind everybody else forevermore. It's just the recognition that we have, if we're going to have a government of laws and not of men, at the end of the day, when the law is applied to resolve a controversy, somebody's decision is final. And my view, based on the text and structure of the Constitution, is that that has been given to the court when it is within their jurisdiction and they have settled that controversy. But that's not to say, again, that the president can't oppose that as a rule to be applied to anybody else from that point forward. He certainly can do that. And presidents have done that. But I recognize too that at the end, what the president decides to do is subject to a political check. And if the president decides to be Andrew Jackson Jr., the only remedy for that will be the impeachment process, and that's okay by me. That's okay. You know, every once in a while, maybe it would be good to have an Andy Jackson come along and rattle the cages a little bit and make federal judges think twice about rendering the kinds of decisions that are so out of whack that it might embolden an Andy Jackson to behave just that way, and the political, what I view as the constitutional wrong, will go unremedied because perhaps it's a response to another constitutional wrong, which I fully view the courts as capable of doing. And it will undermine the authority and independence of the courts, and that's maybe something that judges ought to think about. But that's my answer. Right? Yes?
I was wondering, you talked a lot about this rule as it applies to public officials, and I was wondering whether you thought a similar kind of guiding norm should apply to professionals, particularly people in professions like medicine or law, who take kind of oaths or take on certain ethical responsibilities that may sometimes conflict with their personal morals.
Now that is a little bit of a subject that I did not address. The first part of my address is taken from something I wrote that pertains only to judging, and I didn't use the second half of the address, which deals with what does the professional do in the context of a real conflict between their legal and moral duty, particularly from the perspective of a judge. And there's not, from my perspective, a hard and fast answer to that. Catholic teaching is that when you cooperate with the evil act of someone else, that you do not escape the moral consequences of that. And your act of cooperation can become, in certain circumstances, evil itself. The easy example is what is called formal cooperation with evil. That is where you, the actor, actually share whatever it is as the evil object of the other person with whom you're cooperating. An example would be if someone's inside robbing a bank and you're the lookout. Standing outside on a street corner just looking down the street ordinarily is not an evil act in and of itself, but because you're doing it to share in the evil objective of the person inside holding the gun, obviously you're equally morally responsible, and what you're doing is always morally wrong. The more difficult question from the Catholic perspective is what is called material cooperation with evil, and that is what you're more ordinarily face. What is the mail carrier's responsibility? The mail carrier brings medicine and Bibles and business correspondence and all kinds of things that are either moral goods or morally unobjectionable, and delivers all of that to recipients while also respecting the rules of privacy and prompt delivery that pertain to pornography. From a Catholic perspective of material cooperation, your participation, your cooperation with the evil of delivering pornography is remote. It's not proximate. You don't in any way share the objective of the person who has sent it or is receiving it. You're respecting the rules of privacy because, on balance, they also lead to the prompt delivery and of the life-saving medications and religious materials and all kinds of other things that people would recognize are moral goods. And there's no danger that a mail carrier who respects all of those rules by delivering pornography has sent the message to people that he thinks or she thinks that the evil goods that he or she has delivered are okay. There's no real danger of scandal from that perspective. So that's what you have to face. Ordinarily a judge looks at a controversy and says, look, the law does not allow me to tell this person, to have the force of government prevent this person that they can't do something immoral. Well, you're not sharing in their act. You're not proximately closely cooperating with evil, sending the message to people that you think that is an okay thing. You're just saying the law doesn't empower the government to stop you from doing it. And that's important that the judge uphold the rule of law, because that's what protects our liberty in so many other spheres. The rule of law is what protects religious freedom. It's what protects the right of parents to educate children, and so many other moral goods. So ordinarily, that's not a problem. But every professional faces that potential conflict. There's not a hard and fast rule. What I look to for guidance are the rules of material cooperation that Catholic theologians and philosophers for centuries have developed. But that's what you have to consider. They're tough questions. Thank you.